here from the National Association of Attorneys General. It is known colloquially as the National Association of Aspiring Governors. And as Peter mentioned, the popularly elected, citywide elected Attorney General is very likely to want to run at some point for mayor. And so those are going to affect the judgments that the Attorney General is going to make. And if that Attorney General has control of the hiring and the firing and the promotion and the compensation and the daily activities of the general counsel of the agencies, that is a recipe for trouble. I want to point one thing out, if I can. The district government is really set up in its charter based on the federal government. It's the federal government system. We have a tripartite arrangement. We have, the courts, which are appointed by the president, but we have the legislature, which has all the prerogatives and the speech and debate clause, and we have an executive branch. In the federal system, and this has been the case since the creation of the Department of Justice in 1870, the Department of Justice are the lawyers for the government, for the federal government, for the administration, and they litigate all the cases on behalf of the federal government. But they do not. The Attorney General, who is only an appointed official, the Attorney General is not elected in the federal system, the Attorney General does not appoint the general counsel of the departments or the agencies. Those are appointed basically by the president or by the secretaries of the departments or the agency heads, and those lawyers report to those people. They work together. They do have to follow the legal opinions that the Office of Legal Counsel provides, unless it's overruled by the courts. And that's the same way it has to be in the District of Columbia, that when we have an elected Attorney General, just like now, the agency directors have to follow the legal advice of the Attorney General, but you do not have to control their hiring or firing to have them obey the legal advice.
Okay, I'm glad I asked about a hurdle.
I thought we weren't going to do filibusters here.
No, we weren't, and we were. You get a point, and then we're actually going to hear from Phil.
First of all, we are not the federal government, and when we in 1998 put agency general counsels under the direct supervision of the Attorney General, then called Counsel of the Attorney General, we did so for a reason, to bring about far greater consistency, far greater clarity, and I think it has worked extremely well in that period, in this period of time. And I just want to say for the record that I, for one, am not horrified at the notion that an elected Attorney General might think about running for mayor. We've had a few governors who have been excellent Attorney Generals previously. I don't think that's a bad thing. I don't think that's a disqualification. And I think throwing it out there as if, oh my goodness, somebody would get their hands dirty if they became Attorney General and then wanted to be mayor. I would see nothing wrong with that. I don't necessarily see it as
anything wrong. I'm saying it's a fact of life.
Phil, Mr. Chair.
Good evening. Well, first of all, the way these guys have veered from the question is worse than politicians. The question, I think, was the toughest hurdle.
Yeah.
My single answer would be that everything that the first elected Attorney General does will be precedent setting. If you think about it, the right degree of independence, the right degree of collaboration, striking the right balance in a more political situation than currently with an appointed Attorney General. There's so many decisions and steps and actions, each of which, or most of which, will have some precedential value in terms of how people perceive the office, how the office, just how the office sees its mission. So that's probably the toughest hurdle. If you want, I'll be happy to stray into these other issues. Now, when we had the legislation, the first question was, should the Attorney General be elected? The century of an appointed Attorney General. And I remember testimony from several of the witnesses, which basically came down to there is no perfect model. That you can have an appointed Attorney General and a lousy one, and you can have an elected Attorney General and a lousy one, and vice versa. So there is no perfect model, and I think that's the same issue with regard to what we do with the legal service going forward. we thought with the legislation that there was a net benefit to having the office, all of the office, independent. That is, that all of the attorneys in the agencies are working for the elected Attorney General. And that can go wrong, absolutely can go wrong. But we look no further than the Chief Financial Officer for the District of Columbia for a model, where we see
He's
a
here, by the
position,
way.
a position, we need some money, where is he?
Is he not here? Okay.
I've lost my train of thought.
The CFO office.
Yes, the Chief Financial Officer is traditionally what do I want to say, a senior cabinet member in the executive office of the mayor, whatever, or governor, whatever the government. And yet we have an independent Chief Financial Officer, and I'm reminded time and again of the value, the real value that we have in the council to having an independent Chief Financial Officer. You know, there's really no worse time between the legislative and executive branches than the budget, when the mayor wants to control the budget and the council wants to do what it wants to do with the budget, and we need to go to an independent CFO and get accurate information that we may or may not like, but at least we know that it's more likely to be honest than if it is with somebody who works for the boss who maybe doesn't want to share all the information with the legislative branch. And I don't mean anything pejorative in all that, I just mean to say that there's a value to that independence. I also think there's a value to checks and balances, and we typically think of checks and balances as being the legislative branch as separate from the executive branch, but you can have checks and balances within the branches. We see it with some of the independent agencies. And we see it again going back to the Chief Financial Officer, and I think we will see it with an independent elected Attorney General. And I think that's all to the good. Is it perfect all the time? No. But I think, and our thinking was with the legislation, that on balance it will be a net positive.
Phil, I want to give you another chance. What piece of advice, what would be your number one piece of advice to a new elected Attorney General?
Number one, well, probably going back to what I said before about everything he or she does is a precedent. I mean, it's probably not necessarily, but probably the elected Attorney General will be from the private sector. Maybe not, but if he or she's from the private sector, then there's getting used to the public sector, a very, very wide range of issues, and a different set of values. Something I came to realize a few years into my chairing the Judiciary Committee, the Chief Legal Officer for the District of Columbia is unlike the attorney for any other client, at least in the private sector, and that is that oftentimes the adversaries of the government are also, in a sense, our clients. So we, the government, we're fighting with, let's say, pick a union, firefighters union, we're having a dispute with them, and we're in court with them. But they also represent our employees. So while we're adversaries at the same time, I mean, it's just different than in the private sector. In the public sector, these people are sometimes our clients or our constituents, people that we need to be representing. And it just means that there has to be a different perspective in public service. And so that would be part of the advice as well, is understanding that.
All right. Have we had, Joe, paper and pencil passed out?
No?
Okay, so we're going to, rather than have you write questions, we want to take just a few questions from the audience. And again, the filibuster rule applies to you too, okay? Go ahead.
Thank you. Shannon Frost. I am an attorney with the Civil Litigation Division.
And an alum.
And an alum. And I am also acting president of AFG Local 1403, which represents the lawyers of OAG. And I'd like to get back to the issue of the structure of the office moving forward, since there is this proposal before the council. And as you know, back in 1997, the council had gathered a lot of evidence from Judge Farron and others about how the structure of having the attorneys reporting separately from the Attorney General was leading to fractured legal opinions and the city not being able to speak with one legal voice. And I'd like to ask Irv and have others comment as well. How does your proposal avoid what was happening back before everyone was brought under the Attorney General, so that we can still speak with one legal voice and avoid the fractured legal services that were occurring before?
Well, thanks, Shannon. I think that it should be clear that with respect to all litigation, the elected Attorney General and the Office of the Attorney General has to speak for the District of Columbia, or certainly for the executive branch of the District of Columbia. Second, with respect to the issuance of formal legal opinions, that also has to be done in a single voice by the Attorney General's office. With respect to following that advice and making sure that that happens, our proposal, the mayor's proposal, is that there would be a small office within the mayor's office which would coordinate the activities of the general counsel, intend to ensure, be obligated by the law to ensure that the agency counsel are in fact following that legal advice. I think the Attorney General will have tools to ensure that that happens the same way that the U.S. Attorney General has that ability now. For example, if the agency counsel disregards the Attorney General's advice, then the Attorney General wouldn't defend the agency that didn't follow its advice. It could, and obviously you have a place to go to the mayor to make sure that that happens. And there could even be, in the most extreme circumstances, it shouldn't happen often, but there could even be a lawsuit to require the agency to follow the Attorney General's advice. So there are many ways to ensure that the Attorney General is the one who sets the law, who gives the opinions the same way that the U.S. Attorney General does, and in the same way that the U.S. Attorney General does not control the day-to-day activities of the agency counsel. And I think it's important. It's important to understand what agency counsel do and how that's different from what the Attorney General's office do. The agency counsel have as their client the agency. They are in daily contact with the agency directors and other policymakers within the agency. They are there to help them implement the policies that the agency and the mayor has been elected to carry out. And that is the day-to-day function of the agency director. And it's always the case that if the agency director, the agency general counsel needs advice with respect to a legal opinion, can obtain it from the Attorney General.
Bob?
It will not surprise you to hear I think that's unrealistic. The truth is it used to be, when there was hiring and supervision authority, that the lawyers in the agency saw the director as their client to the exclusion of the rest of the District of Columbia. And so it is true that the Attorney General issues its big legal opinions, but every day in and day out, general counsel are giving legal opinions to their agency directors and the staff who work there. At the moment, they are tethered under the supervision of the Attorney General, who can coordinate that, who can see when there are differences, who can at least put them in a room together and hash out what the right answer would be. The chances of that happening under the proposed restructuring, I think, are minimal. Not to mention the fact that it's the practical realities of having a director hire, fire, pay, supervise, evaluate independently of every other. And as I understand the proposal for the director of the mayor's legal office has coordination but not supervision authority. So you can imagine the turnover that will occur each time an agency changes leadership, because they will want their own lawyers, people that they've had a relationship with before. And I can give you a laundry list, and we could debate this forever, but I also want to just touch on...
Our next panel.
I just want to touch on the U.S. government comparison. We are not the United States government. And the agency counsel, the general counsel in the agencies, are not sort of focused on just the policy. DOT, Federal Department of Transportation, is not just experts on the national highway safety, blah, blah, blah.